My name is Brian Garland. I'm one of the partners in Gerald Thomas. And we thought that as Brexit has now come back onto the front page and is very much the topic of conversation, that we would get together some people whose thoughts would be valued on this. And we've got 4 speakers who no doubt will introduce themselves as we feed through the question and answers. And it's very much a case of trying to look at relevant and pertinent points that businesses should prepare for at the current time. Obviously, the accountants will deal with the accounting and financial matters, and the lawyers will deal with the legal sections with regard to employment and contract law. So without further delay, I shall introduce you to Hannah Belton, and she will talk to you about employment law. Hannah, perhaps you'd like to introduce yourself, and then I'll raise a couple of questions with you.
Thank you, Brian. So as Brian said, I'm an employment solicitor with Morgan La Roche solicitors, and we've been looking at Brexit obviously for a while in terms of preparing our clients for what things they may need to think about in the future. So of course, after Brexit, the UK will no longer be a member of the EU, but the terms of the divorce at the moment are still far from agreed. However, what we do know is that the principle of supremacy of EU law will no longer apply in the UK, and all lawmaking powers will be devolved back to the UK Parliament. A substantial component of UK employment law is grounded in EU law. But in some cases, EU law has entrenched provisions across its member states and taken its cue from UK laws. So, for example, race discrimination and certain maternity rights have been copied in the EU by what was already in existence in the UK. In other cases, new categories of employment rights have been transposed into domestic law to comply with emerging EU obligations. And the most obvious of these in the context of employment law is the agency worker regulations.
So do you see the UK turning its back on the European Court of Justice? Do you think it'll go that far?
Not completely. So it's true as of the 31st of December 2020 that a court or tribunal will be bound by decisions made by will not be bound by decisions made by the ECJ after that date. But in relation to matters that can be referred to after that date, the UK laws can still look to the ECJ to determine decisions on relevant cases that UK law is looking at. So this means that parties in dispute can still rely on the ECJ decisions made after the 31st of December 2020 when we leave the EU, if they're relevant in determining the UK dispute.
So what do you feel is going to be the impact on key UK employment legislation, and what might change post-Brexit?
So crystal ball exercise. I don't think any of us really know what's going to happen, but in terms of my top 6 predictions for employment law, looking at discrimination law, the Equality Act is obviously something that's been established into UK law for 10 years now, and it's difficult to imagine that employers or employees will be pleased to remove any of the discrimination grounds that are relied on in the Equality Act. It's something that's become so entrenched into the UK law that both employers and employees know it's not lawful to discriminate against employees in any circumstances. What we may see in relation to discrimination law is a cap, though, on compensation. So at the moment, there is no cap on discrimination compensation in the UK if an employer has been found to unlawfully discriminate, whereas unlike things such as unfair dismissal, there is a cap on how much can be claimed by an employee. So it is possible that UK government may look at introducing a cap to that compensation. There's also a possibility that government may look at legalising positive discrimination, especially in the public sector, where it will be legal to basically favour underrepresented groups in terms of things such as recruitment and selection. Looking next then at family-friendly leave. Family-friendly leave in the UK is again a mix of rights that the UK established, which potentially the EU have copied the UK and taken its cue from us, but also rights then that have been established in the EU that have been transposed directly into the UK legislation. So for example, UK maternity pay and leave, this preceded the EU rights that are currently in existence and is actually more generous in the UK than it is in the EU. So it's unlikely we're going to see any changes in respect of that. Things such as the right to shared parental leave and flexible working, they are only rights that exist in the UK and don't exist in the EU. So again, it's unlikely we're going to see any changes in relation to family-friendly leave. Transfer of undertaking, so the 2P regulations, this may be something that will be looked at changing because it's something that is generally unpopular with employers and businesses when there's a transfer of a business undertaking or outsourced activity. However, having said that, generally speaking, most businesses are so familiar with the terms now that the cost of a 2P transfer of employees, for example, is incorporated generally into commercial outsourcing agreements. So if the government are going to make changes, it will probably be only small changes, things such as making it easier for employers post 2P to harmonise terms and conditions of those staff transferring across to them. Holiday pay and working time, I think this is where we're probably going to see the biggest changes because of the establishment of cases over the last few years. So generally speaking, it's been unpopular in the UK, the way the holiday pay cases have been established by European courts, such as allowing people on sick leave to continue to accrue holiday, not capping the amount of holiday pay people on sick leave can carry over from one year to the next, and also the maximum working week of 48 hours have all been quite unpopular in the UK. So all of those things may potentially be looked at being changed by the UK government after Brexit. Collective redundancy, in the climate we're in at the moment, we're giving lots of employers redundancy advice, and there are certain rules in terms of how long you have to consult with staff depending on how many employees are being made redundant. So for example, if an employer is looking at dismissing 100 or more employees, they have to start consultation 45 days before the first notice of termination is issued. It's not particularly onerous, but as I said, based on the current climate, there may be some appetite to looking to reduce that 45-day period, maybe akin to the 30-day period that we see with less than 100 employees. And then finally, agency workers. I think this is going to be the most obvious piece of legislation that initially is looked at because the UK government effectively copied word for word what the EU regulations say in relation to agency workers. So it would be something that won't necessarily be difficult to politically unpick if that's what the UK's appetite is. Having said that, there was the recent Taylor review a couple of years ago that actually said they were looking at strengthening agency worker rights in the UK. So it will become a political hot potato, I think, in terms of whether or not there are going to be any changes to the agency working regulations. So in summary, very little is going to change immediately, especially in the short to medium term, but over a longer period, we may look at some slight changes to employment law. There's obviously very little appetite at the moment in terms of the UK government with everything else that's going on in terms of making radical changes because of obviously the amount of time that the government will have to take to make those changes, but also bearing in mind how unpopular some of those changes will be with trade unions and employees. And let's not forget that the Supreme Court will, after December 2020, have powers to overrule the European Court of Justice decisions, though whether or not they do will remain to be seen. Thank you.
Thank you, Hannah. Thank you very much for that. I'm now going to ask Phil Williams, one of the partners in Gerald Thomas, to introduce himself. And Phil is going to talk about the issues of importing and exporting post-Brexit.
Well, good afternoon, everybody. My name is Phil Williams. I'm tax partner here at Gerald Thomas. And I just want to sort of summarise some of the basic changes that are going to take place as from the 1st of January, when we leave, or when we finally leave the EU. So the first question that I really wanted to deal with is how VAT will be handled on goods from the EU. As you know, at the moment, it's fairly seamless that when goods come in from the EU, then there are no real difficulties in accounting for the VAT on that. And it's always has been a fairly seamless process. But for any of you who regularly import goods from outside the EU, you will know that the situation is quite different. and as from the 1st of January, then it's going to any goods coming in from the EU are going to mirror our exports from other imports from other parts of the world. Basically, when you import from the EU, then VAT is going to be charged on the goods that are imported. The charge will be raised at the point of entry into the UK, and this will be along with other import duties which may arise on the particular goods that you are importing. The bottom line is that VAT will need to be paid together with those import duties before the goods are released to the customer. Now, that can obviously create some problems, especially in terms of cash flow, that if you need to get the goods into your factory or wherever, that you've got to pay all those duties before they're actually released to you. But there is a VAT deferment method, and you can set up a VAT deferment account, which may be used to enable an importer to bring goods into the UK without paying the import VAT up front. And instead, the import VAT and duties will accumulate in that deferment account, and the total liability for a month will be payable by the 15th of the following month. Now, you can set up a VAT deferment account. I understand it's not particularly onerous. There are a few hoops that you have to you have to jump through, but you may well, if you use a customs and freight agent, you may well be able to use their own deferment account, although I'm sure if you do that, they will charge you for doing it. A VAT deferment account, it would be of assistance if you have a large volume of imports coming into the UK. The VAT is charged, as we've said, at the point of entry, and the VAT duties and the import duties are charged at that time. But in order to be able to recover any VAT that you've been charged, you need to ensure that you are issued with a valid C79 certificate. When HM Revenue and Customs review your VAT returns, as they do quite regularly, as I'm sure many of you realise, that is that if you've imported goods, they will expect to see the certificate as a support for the legitimacy of reclaiming any VAT on those on those imports. They can be quite strict on that. Basically, what the legislation says is that it's normal for you to have the C79 if you can prove in some other way that you've paid the VAT, then they may allow it. But the easiest method is to make sure that you always get the form C79 declaration when you import goods.
So in terms of the kind of import of goods, you've covered that, Phil. What about the export? How is that going to change?
The export of goods is basically exports of goods are going to be zero rated to the EU, just as they are to the on a worldwide basis. The only thing that you need to keep is you must have evidence of the goods having left the UK to support the zero rating. There are other documents that you need to keep as well. You need to have an EORI number. I think many people who are trading with the EU have already got that, and you need to have the relevant customs forms in terms of going forward when you export. But again, it's just you just need to make sure you've got the right documentation to show that the goods have left the UK, basically. So that's fairly straightforward with regards to the exporting as far as VAT is concerned. I think there are perhaps more difficulties when you come to the other export tariffs and things like that you need to have there and you need to have available. Yeah.
So in terms of the points you've mentioned, we've talked about goods in and goods out. how does it work with regards to supplying services?
Right. The services just really depends on who you're supplying. Okay. When it's a business-to-business service, so for instance, if you're a solicitor's firm or an accountancy firm and you're supplying a service to somebody in Germany or in France, and the taxability or the VATability, if I can put it that way, is based on where the customer is located. So basically, if it's on a business to business, if the customer is located outside of the UK, then it's a zero rate. So there's no issue on that. Okay. If it is a business to business supply, so you are receiving services, then a UK purchaser will account for that under the reverse charge rules, as if the purchase is from outside the UK. So basically, you account for the VAT on that supply through your own VAT return. If it's a business to customer sale, so for instance, if you're supplying tax services or legal services or whatever to somebody who is a resident in another country but don't run their own business, then again, the general rule, and it will still apply, is that VAT is charged on the basis where the supplier is located. So that's where you would account for VAT on that basis. Okay.
Thank you, Phil. I'm next going to turn to Rhys ap Gwent, who is an expert on contract law. And first of all, I'll let him introduce himself.
My name's Rhys ap Gwent. I'm one of the solicitors at Morgan La Roche, and I specialise in in commercial contracts and the contractual protection of intellectual property and data protection.
So, Rhys, in terms of Brexit, what kind of effect do you think it will have on the legal contracts that are currently drawn up by UK companies?
Well, it's very interesting watching what's going on at the moment, because with negotiations heading into the 11th hour and still no sign of a deal, this does raise quite a lot of questions for contract law. If we do end up without a deal and parties either side of the channel find themselves trading on WTO rules. So the effect on contract law itself won't be very substantial, because most of the laws which govern contracts actually come from the UK, so they won't change. And where the laws do come from Europe, most of the laws from Europe which affect commercial contracts they'll all be part of the retained EU law, which will continue to be mirrored in our law from the 1st of January. But what really businesses need to think about in terms of their contract is more to do with their own circumstances and the circumstances on which deals were made, and how the change in the economic landscape is going to have an effect on their ability to deliver their side of the bargain. And they'll have to take into account things like increases in costs and changes in procedure, which could all have a knock-on effect onto their contracts and make them more difficult to deliver. So some businesses whose circumstances will have changed will be looking of ways of relief or ways of getting out of a contract. So they might find, say, thanks to tariffs on goods crossing the channel, the contract is no longer viable, and they might either seek to rely on a force majeure clause, which is when an event outside of your control has prevented you from delivering your end of the bargain. They might seek to look for avenues of enforcing a clause like that, or they might say that the contract is simply now undeliverable and is frustrated. And some businesses might try to get out of contracts by arguing that Brexit has frustrated their contracts. But there was a High Court decision which might make this difficult, that the European Medicines Agency, of course, is an EU body that's located in London, they're tied into a 25-year lease for their premises in Canary Wharf. They tried to end that lease, saying that it was now frustrated because they won't be in London anymore. And the High Court concluded that Brexit doesn't frustrate the contract and that they're still tied into that lease. So that's a decision that I think might have worried a number of businesses who don't want to trade after Brexit, or certainly want to alter the way they trade after Brexit. So there's likely to be some commercial disputes which arise, and disputes, of course, will be handled differently, because currently we're part of an EU-wide framework for handling disputes between parties in different member states, where there are regulations setting out things like the service and the enforcement and recognition of court decisions. This framework won't apply from the 1st of January. So there'll be more pressure on businesses to find their own resolutions to any of the disputes that might arise. So I think it's worth having a think of some of the changes that are going to happen next month that could have a knock-on effect on contracts, so that businesses can anticipate these changes and prepare for them in any way that they can. So supply chains are likely to be affected as a number of tariffs on things like food products come into effect. There's going to be changes of procedures at the border, things like the Kent access pass. Even if hauliers have made all the preparations, all these processes take time to bed in. So there's likely to be some delays in that respect. A lot of components travel back and forth across the channel before being made into the final product. So this could well be slowed down. And then there are all sorts of regulatory things that businesses will have to think about. Things like certifications and licenses and industry regulations there'll be a separate set in the UK and in the EU. So there'll be a doubling up of the admin on that type of thing. And then interestingly, there will be effects on labelling, where we won't be part of the CE mark anymore. There'll be a UKCA mark will come into place instead. And for professionals who deliver services currently on the continent, people don't know whether their qualifications will still apply. Some are known. For instance, as solicitors qualified in England and Wales, we will no longer be able to advise on EU law. Some firms have paid for their staff to become qualified in Ireland as a way of continuing to do this, but the Law Society in Ireland interestingly said that they won't maintain the qualifications unless you practice in Ireland. So that's another issue. And of course, the movement of professionals who travel abroad to deliver their services could be hindered as well, with more things like work permits and things like that in each member state that they'll have to think about. So in terms of intellectual property, anyone who holds a EU-wide trademark, this will continue to apply in the EU, and then it'll be made into an equivalent UK right. But anyone who wishes to apply for a EU-wide trademark in future will have to instruct an EU-based lawyer to do so. But copyright copyright is the automatic right that arises to protect all creative expressions, and so this applies to text, graphics, music, all this type of thing. This won't be affected by the end of the transition period, because these are rights that are come from international treaties as opposed to EU law. So that's one area that won't change. But just that was a quick overview of just a number of things that are likely to change, and likely to change the circumstances of parties to contracts, and things that businesses will have to think about. So and it'll be a long time really before we know what the new legal landscape looks like. A lot of the retained EU law might stay in place, or it might be changed. But a lot of it, a lot of EU law that we currently follow, when it was contemplated, it had UK support. So there's no obvious reason for removing it. So essentially, to conclude, businesses will want to think about what they need to do looking forward, looking ahead now until January. And so really three actions that would be beneficial would be to consider all the economic changes that I described and anticipate any that might have an effect on the ability to deliver the contract. Businesses should look at read all the contracts that they currently have in place to see if there are any Brexit provisions, or if they need to be updated with a removal of any language, such as references to EU institutions that no longer apply. And people might need to renegotiate their contracts to allow for the changes in circumstances that will take place from the 1st of January. And in terms of entering into new contracts, it's worth putting in clauses to anticipate events that could arise from Brexit, such as changes in the law that businesses might be concerned about within their own sector, and also to make sure that any clauses for the resolution of disputes are appropriately drafted, with preferably some sort of alternative dispute resolution that the parties can organise between themselves. So that really is in a nutshell what all businesses party to contracts which cross the channel, the things that they should be thinking about.
Thank you, Rhys. That's been very comprehensive. I'd next like to ask John Evans, another one of my partners, to introduce himself. And John will answer a couple of questions about the impact of cash flow.
Thanks, Brian. I'm John Evans. I'm a partner in Gerald Thomas, and I spend seems to be a lot of my time talking to businesses about the way in which they trade and their financial matters.
So, John, how do you think that the impact of Brexit, the impact it will have on items such as cash flow for businesses?
Well, I think that what's been heard already suggests that there are two main impacts upon the financial situation of businesses. First of all, there's the additional costs. You know, Rhys has talked about tariffs, and that tariff had to be paid for, and the payment has to be received by the businesses operating in the UK. And if a business is not astute in its contract terms, then it's not going to be able to recover those tariffs from its trading with its particular customers or suppliers. So that's one issue. But the second one is the delays that take place. Now, Phil has been talking about VAT, and there is the potential of VAT being timed differently. So it is important for businesses to examine where they are in relation to that. Phil's talking about postponement or deferral accounting, and that's one method in which that tax impact can be mitigated. Otherwise, an importer, for example, is going to be faced with paying out VAT much earlier than what it did before. And obviously that VAT cost would need to be financed. And that finance would take working capital out of the business. So that's one area where the businesses are going to have to be very careful in the way that they plan their operations. Now, about over 12 months ago, when the Brexit decision was taken, clients of mine were being forced to increase the stocks that they held. Some of their customers were fearful that the supply chain would be impacted by delays at the border, And they were saying to suppliers, well, we require you to increase your stock levels. And what that was doing was taking, in some cases, millions of pounds out of the working capital of the supplying business. And we're now coming to the situation where that is going to be a reality. And it may well be that we will see the same thing happening yet again. Even if it doesn't, the delays that have been talked about in relation to goods being transferred between the UK and the EU and all the publicity that has surrounded delays at ports will also impact upon the way in which cash will be, or the timing that cash will be received. Because the longer it takes to come in, the longer it's going to take for you to be able to sell it on. So that's another area that will need to be factored in to the consideration of a business's cash flow. The other thing that could well happen is that the delays of delivery might impact on the ability of a customer to sell its goods on to another company. So even if you yourself feel that you can get your supplies in quickly, it may be that some of the components that you are incorporated into your product are being imported, although you buy them from a UK supplier. And if you have delays in the sourcing of those components, that too can restrict your ability to be able to get your product out of the door with the same speed that you once did. All these things can impact upon your potential cash flow. There may be necessary that you can mitigate this in the negotiation of credit terms, both with suppliers and customers. And all of these factors have the ability to impact upon those who import themselves, those who export themselves, or those who are in the middle of a supply chain where there is import and export going on. So the impact is fairly wide-ranging, even if you yourself may not be an importer or an exporter. And the last impact that no doubt we will see is that in getting paid, your people are going to use Brexit as an excuse to delay payments. Put that all together, it does have the probability of quite a severe impact upon cash flows of businesses.
So what can businesses do to ensure that they've got adequate funds in place to cover these eventualities?
Well, this is where I think business need to focus on the problem. With the effects of coronavirus over the course of the last 9 or so months, many businesses have understandably have had their focus on coronavirus and managing their businesses in this. And with the hope that there will be some form of deal in Brexit that might make some of these problems go away, I think that there are a number of businesses who have not yet concentrated their minds on the impacts. The first thing that they need to do is to be aware of what cash flow they require, were it not for any Brexit problems, so that they know precisely what their base figure is as far as cash requirements. Now, in doing that, they will need to take into account the increased borrowings that many businesses have as a result of Brexit. There have been a vast number of businesses who have applied for government guaranteed loans, which will become repayable over a period of time, so that this will impact upon future cash flow. In addition to this, there is VAT that has been past VAT liabilities which have been deferred, which again will become payable in the future, and that has to be taken into account. So the first thing that I would be advising clients, and have advised clients, is to look at their baseline cash flow. The next thing to do is to identify those impacts that we've already talked about, and to see how that they might impact upon their cash flow. Now, in doing that, it's very difficult for businesses to be certain. So what a business needs to do is to look at a variety of possibility of outcomes. So what they will need to do is to look at what ifs dependent upon increased stocking, slower receipt of supplies, how that they might mitigate that, and how those problems might untangle over time. They might look at their trade-in terms to ensure that the terms are not to be adversely affected by the changes that are taking place. They might look at the way in which they finance their business. If they've got some form of invoice discounting, how is that going to be impacted if they are selling to businesses now outside the EU? But the main thing to do is to look at the possible scenarios and to look in detail of some form of cash flow forecast and then vary it for the possible variations. And then look at the cash availability that the business has and its lines of finance and ensure that it has a clear plan that enables them to ensure that all the reasonable scenarios that they might predict will be covered by the availability of cash flow that their current financing provides. If they find that there are going to or likely to be any shortfalls in that, then it is better for them to address those shortfalls now, speak to banks or other lenders, and ensure that those shortfalls can be overcome.
Thank you, John. I'd just like to kind of sum up now. I mean, obviously, the speakers have illustrated how potentially complex and challenging the Brexit and whatever form it might take is likely to be from a financial and a legal perspective. Obviously, if you feel you need any further advice, then please do not hesitate to contact us. The details will be put up towards the end of this session. And certainly, as far as Gerald Thomas is concerned, we have a Brexit checklist, which is a useful source of information and early steps for people to proceed. And I'm sure that my legal colleagues can also provide information as and when you require. Thank you very much for listening, and I hope this has been thought-provoking and made you think that perhaps now is the time to act. Many thanks.